Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in for this post-decision episode of SCOTUScast. I'm your host, Nick Garfinkel. On June 23, 2021, the Supreme Court decided Cedar Point Nursery v. Hassid, a case which concerned whether California regulation granting labor organizations a right to access to an agricultural employer's property to solicit support for unionization constituted a per se physical taking under the Fifth Amendment. Chief Justice John Roberts authored the 6-3 majority opinion of the court, holding that California's access regulation constitutes a per se physical taking. Joining me today to discuss this decision is Wen Fa, attorney at the Pacific Legal Foundation.
All right, thank you so much. It's great to be back on, and fortunately, we have some very positive news to announce. Earlier this morning, the Supreme Court of the United States handed down what I believe to be one of the biggest cases this term and one of the biggest property rights cases of the last decade, and that is its decision in Cedar Point Nursery versus Hassid. In this case, I am very pleased to be working on the litigation team with my colleagues Joshua Thompson, who argued the case, and Chris Keyser and Damian Schiff. We represent two California growers, Cedar Point Nursery, a grower in Northern California that plants strawberry plants, and also Fowler Packing Company, a business in Fresno that specializes in mandarin oranges and table grapes. The challenge in this case actually started in February 2016. When we launched this case in the U.S. District Court for the Eastern District of California, we challenged a access regulation, California access regulation, that allowed labor organizations and allowed union organizers to the ability to go on the private property of every agricultural business in California for 3 hours per day and 120 days per year. And this was applied to our clients in some very, egregious ways. So, for example, Cedar Point, during a busy harvest season in 2015, union organizers came unannounced at 5:30 in the morning, worked their way through the trim sheds with bullhorns, and actually intimidated and scared many of the workers during a peak harvest season in 2015. So we challenged this regulation as a taking under the Fifth Amendment to the United States Constitution. And the central question in this case, and what makes this case so important, is whether this taking is a per se physical taking or a regulatory taking. And that question is really critical because a physical taking invokes a categorical rule in which the government is obligated to pay just compensation. And we didn't even allege a regulatory taking we didn't even allege a regulatory taking claim because under a multi-factor balancing framework in regulatory taking cases, the government can literally take millions of dollars in value, deprive the property owner of millions of dollars in value, and not even have to provide a penny in just compensation. So our claims were actually rejected at the district court and then again at the Ninth Circuit Court of Appeals. Both of those courts held that this is a regulatory taking subject to a multi-factor balancing test. And since we did not plead that it was a regulatory taking, our case had to be dismissed. Now, the panel decision in the Ninth Circuit actually involved a dissent arguing that we should have a chance to prove our claims, and we petitioned for rehearing en banc. And what the en banc panel, although it declined to rehear this case en banc, garnered a very positive opinion, dissent from denial en banc, which was authored by Judge Ikuda and joined by seven other judges in the Ninth Circuit, which said that, this is subject to the categorical rule and should be given per se analysis. So we then petitioned to the Supreme Court. It was granted. The petition was granted in November of last year. And my colleague Joshua Thompson, as I mentioned, argued this case in March. The Supreme Court decision this morning was very favorable, adopted many of the arguments that we raised in our brief, and it held that a physical taking, or actually a regulation that involves physical occupation and a physical invasion of private property, and a regulation that really limits the property owner's right to exclude, amounts to a physical taking under the Fifth Amendment. This was, as we argued, backed by decades of Supreme Court precedent, going back to cases like Portsmouth Harbor, which involved a government firing of cannons over private property, and all the way up to Nolan versus California Coastal Commission, which was actually PLF's, this was PLF's 13th win before the Supreme Court of the United States. Nolan versus California Coastal Commission was the first PLF win before the Supreme Court of the United States in 1987. And in that case, the court held that a California demand that private property owners essentially give up an easement on their private property in order to be able to rebuild their beachfront property was an unconstitutional condition. And included in that analysis was the fact that if the government had just taken that easement outright, it would have been a per se physical taking subject to the just compensation requirement. So the government's, or actually I should say the Ninth Circuit's reasoning in saying that this was a regulatory taking was sort of odd in that it said, it distinguished Nolan on the ground that Nolan allowed for 24/7, 365 access, and in this case, the access is limited to 3 hours per day, 120 days per year. But as the Supreme Court pointed out in today's opinion, the facts of Nolan, the beach was not even accessible 365 days per year in Nolan. And even if it had, the takings clause is not so feeble to where the government can just avoid its duty to pay just compensation just by limiting access to, say, 364 days per year or 23 days, 23 hours out of each day. And I think the Ninth Circuit's rationale in this case, in the opinion below, was so extreme that even the government, the California ALRB, abandoned that position in its response brief. It said that this is a regulatory taking, but it didn't necessarily argue that a physical occupation had to be 365 days out of the year, 24/7, in order to be a physical taking. But it also did not draw a line for determining what would be a regulatory taking, what would be a physical taking in its response brief. The Supreme Court opinion today also distinguished Pruneyard, which is a case that was the primary case relied upon by the government below. And in Pruneyard, it distinguished Pruneyard on the grounds that in Pruneyard, the property there was a shopping center that was open to the public at large. So you did not have the same right to exclude. In fact, the property owner in Pruneyard did not typically limit its property or exercise its right to exclude against anybody. In this case, these are private businesses. They're only open to the workers on on business grounds. So the right to exclude is much, much stronger in that case. And I think there's a world of difference between this type of property and the sort of public place of public accommodation that was at issue in Pruneyard. So I think the court correctly addressed the Pruneyard, or the court correctly distinguished the Pruneyard decision. There is also the decision in NLRB versus Babcock and Wilcox, which sort of did a sort of balancing analysis between the private property rights of businesses and also a union's right to, or I guess the workers' right to learn of, union, the right to join a union. And the court correctly distinguished Babcock on grounds that Babcock was a case involving statutory interpretation. It didn't involve a takings claim. It didn't say anything about the takings issue that have been presented. And I think, as Judge Kavanaugh noted, in this case, we would have won even under the Babcock approach because the employees, I should say, at both Cedar Point Nursery and Fowler Packing are accessible off-site to union organizers. In fact, union organizers attempted and were able to speak to a lot of the employees off-site. So the court also correctly dealt with Babcock. And, in line with those two decisions, Pruneyard and Babcock, the court turned to a sort of parade of horribles that were raised by the dissent and also by the government at the merit stage. We don't think there's much merit to those parade of horribles. We invoke several avenues for distinguishing them, and the court adopted all of them. So, for example, there are background principles of property rights. So, if one did not have a background principle or one did not have a right to exclude certain others, for example, government inspectors at common law, then that right to exclude is not a part of, a property owner's property interest. But here, there was no common law analog to union organizers being able to access private property for their private purposes for 3 hours per day, 120 days per year. And so the court correctly recognized that this regulation impinged on the property rights the property owner's common law right to exclude unwanted third parties. It also, addressed many of the inspection cases by using the Fourth Amendment. Because a property owner traditionally had no right to exclude an official that was actually engaged in a reasonable search, government searches that are consistent with the Fourth Amendment intuitively cannot be said to take any property right from landowners. There were other ways for distinguishing many of the examples raised by respondents in their amici. I won't go through all of them, but one other notable one that was raised by the Chamber of Commerce amicus brief, authored by former Judge Michael McConnell, was that there's a long line of cases holding that when the government conditions the grant of a benefit, such as a permit, on allowing access for reasonable health and safety inspections, that might be constitutional as a constitutional condition as long as it meets the nexus and rough proportionality requirements enunciated by the Supreme Court in cases like Nolan and Dolan. So the Chief's majority opinion for the court was joined by Justices Kavanaugh, Gorsuch, Alito, Thomas, and Barrett. Judge Kavanaugh also wrote a separate opinion saying pretty much what I said earlier, that there was another avenue for plaintiffs to win in this case, which was that that under the balancing test established by Babcock, we would win under that test as well. But I think the primary reason we win is by applying the per se physical takings analysis. Justice Breyer authored a dissenting opinion joined by Justices Sotomayor and Kagan, in which Justice Breyer stated his view that this should be considered under the multi-factor balancing test of Penn Central. But, one interesting part about Justice Breyer's opinion that I noticed was, I think he calls the Penn Central balancing test flexible and views that as a feature and not a bug. But on the ground practice, as a lot of property attorneys know, the multi-factor balancing test under Penn Central is notoriously unfavorable for property owners. I've seen cases where a property owner lost up 95% of value and did not receive a penny in compensation. So that's just another reason why this is such a big case for property rights and property owners across the United States, in that it establishes that the per se physical taking doctrine applies, and the government has a duty to compensate the property owner for any taking of property that's analogous to the taking in this case. So, the upshot of this case, I think there is a lot to be litigated in future cases, but it is a very big case for property rights, and it's a big win for liberty. I think this is one of the biggest wins for individual liberty this term. Property rights is obviously central to the notion of individual liberty in the United States, and this case vindicates important property rights.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.